International Convention on the Protection of the Rights of All Migrants Workers and Members of Their Families, Episode 7. Article 48, 1. Without prejudice to applicable double taxation agreements, migrant workers and members of their families shall, in the matter of earnings in the state of employment, a. Not be liable to taxes, duties or charges of any description higher or more onerous than those imposed on nationals in similar circumstances, b. Be entitled to deductions or exemptions from taxes of any description and to any tax allowances applicable to nationals in similar circumstances, including tax allowances for dependent members of their families. 2. States parties shall endeavour to adopt appropriate measures to avoid double taxation of the earnings and savings of migrant workers and members of their families. Article 49, 1. Where separate authorizations to reside and to engage in employment are required by national legislation, the states of employment shall issue to migrant workers authorization of residence for at least the same period of time as their authorization to engage in remunerated activity. 2. Migrant workers who in the state of employment are allowed freely to choose their remunerated activity shall neither be regarded as in an irregular situation nor shall they lose their authorization of residence by the mere fact of the termination of their remunerated activity prior to the expiration of their work permits or similar authorizations. 3. In order to allow migrant workers referred to in paragraph 2 of the present article sufficient time to find alternative remunerated activities, the authorization of residence shall not be withdrawn at least for a period corresponding to that during which they may be entitled to unemployment benefits. Article 50, 1. In the case of death of a migrant worker or dissolution of marriage, the state of employment shall favourably consider granting family members of that migrant worker residing in that state on the basis of family reunion and authorization to stay. The state of employment shall take into account the length of time they have already resided in that state. 2. Members of the family to whom such authorization is not granted shall be allowed before departure a reasonable period of time in order to enable them to settle their affairs in the state of employment. 3. The provisions of paragraphs 1 and 2 of the present article may not be interpreted as adversely affecting any right to stay and work otherwise granted to such family members by the legislation of the state of employment or by bilateral and multilateral treaties applicable to that state. Article 51. Migrant workers who in the state of employment are not permitted freely to choose their remunerated activity shall neither be regarded as in an irregular situation nor shall they lose their authorization of residence by the mere fact of the termination of their remunerated activity prior to the expiration of their work permit, except where the authorization of residence is expressly dependent upon the specific remunerated activity for which they were admitted. Such migrant workers shall have the right to seek alternative employment, participation in public work schemes, and retraining during the remaining period of their authorization to work, subject to such conditions and limitations as are specified in the authorization to work. Article 52, 1. Migrant workers in the state of employment shall have the right freely to choose their remunerated activity, subject to the following restrictions or conditions. 2. For any migrant worker, a state of employment may a. Restrict access to limited categories of employment, functions, services, or activities where this is necessary in the interests of this state and provided for by national legislation. b. Restrict free choice of remunerated activity in accordance with its legislation concerning recognition of occupational qualifications acquired outside its territory. However, states parties concerned shall endeavour to provide for recognition of such qualifications. 3. For migrant workers whose permission to work is limited in time, a state of employment may also a. Make the right freely to choose their remunerated activities subject to the condition that the migrant worker has resided lawfully in its territory for the purpose of remunerated activity for a period of time prescribed in its national legislation that should not exceed 2 years. b. Limit access by a migrant worker to remunerated activities in pursuance of a policy of granting priority to its nationals or to persons who are assimilated to them for these purposes by virtue of legislation or bilateral or multilateral agreements. Any such limitation shall cease to apply to a migrant worker who has resided lawfully in its territory for the purpose of remunerated activity for a period of time prescribed in its national legislation that should not exceed 5 years. 4. States of employment shall prescribe the conditions under which a migrant worker who has been admitted to take up employment may be authorized to engage in work on his or her own account. Account shall be taken of the period during which the worker has already been lawfully in the state of employment. Article 53, 1. Members of a migrant worker's family who have themselves an authorization of residence or admission that is without limit of time or is automatically renewable shall be permitted freely to choose their remunerated activity under the same conditions as are applicable to the said migrant worker in accordance with Article 52 of the present Convention. 2. With respect to members of a migrant worker's family who are not permitted freely to choose their remunerated activity, states parties shall consider favourably granting them priority in obtaining permission to engage in a remunerated activity over other workers who seek admission to the state of employment, subject to applicable bilateral and multilateral agreements. Article 54, 1. Without prejudice to the terms of their authorization of residence or their permission to work and the rights provided for in Articles 25 and 27 of the present Convention, migrant workers shall enjoy equality of treatment with nationals of the state of employment in respect of a. Protection against dismissal, b. Unemployment benefits, c. Access to public work schemes intended to combat unemployment, d. Access to alternative employment in the event of loss of work or termination of other remunerated activity, subject to Article 52 of the present Convention. 2. If a migrant worker claims that the terms of his or her work contract have been violated by his or her employer, he or she shall have the right to address his or her case to the competent authorities of the state of employment, on terms provided for in Article 18, Paragraph 1 of the present Convention. Article 55. Migrant workers who have been granted permission to engage in a remunerated activity, subject to the conditions attached to such permission, shall be entitled to equality of treatment with nationals of the state of employment in the exercise of that remunerated activity. Article 56. 1. Migrant workers and members of their families referred to in the present part of the Convention may not be expelled from a state of employment, except for reasons defined in the national legislation of that state, and subject to the safeguards established in Part 3. 2. Expulsion shall not be resorted to for the purpose of depriving a migrant worker or a member of his or her family of the rights arising out of the authorization of residence and the work permit. 3. In considering whether to expel a migrant worker or a member of his or her family, account should be taken of humanitarian considerations and of the length of time that the person concerned has already resided in the state of employment.